Man, what has been going on with SBF? I mean, did he just fall off the face of the earth? Is he hunkered down in his parents' basement to ride out his criminal charges? No. His lawyers have been working hard doing what lawyers do. As a lawyer, as America's attorney, I'm in the unique position to relay information to you in a way that's so easily consumable that you want to lawyer up and subscribe for your shocking leveling up of your entire life. Maybe. Now, as we all know, the Southern District of New York has brought 13 charges against SBF Samuel Bankman-Fried, including conspiracy to commit wire fraud, actual wire fraud, bank fraud, bribery, and so much more. Now, SBF's lawyers have filed a motion to dismiss 10 of the 13 charges. I mean, they're really going for it. Well, not all of it, but if they succeed, SBF might only have to spend like a decade in jail as opposed to 4 or 5 decades. In multiple memoranda of law, aka legal briefs, SBF's lawyers tried to convince the judge to dismiss over 75% of SBF's charges. So let's break down some of their arguments. As you may recall, SBF's first and second charges are conspiracy to commit wire fraud on FTX customers, and then, of course, the actual wire fraud on FTX customers. SBF and his lawyers are claiming that these 2 counts should be dismissed because they do not identify a property interest that can form the basis of wire fraud against FTX's customers. What do they mean by that? They do not believe, or they don't want the court to believe, that a tangible economic loss was properly alleged in the indictment. The losses the indictment does allege, such as a right to honest services, loss of control of assets, deprivation of information, do not qualify as great enough losses to create a wire fraud offense, according to SBF's argument. They then describe 4 cases in which courts have limited the scope of the word property. This is interesting. These cases like Skilling and Cleveland do seem to suggest that exposure to risk alone is not enough, but that instead there might need to be a real loss. For instance, there's a way of reading these cases that says that if you use the wires to conduct a business that takes in money and then, without telling your customers that you're going to behave in a risky way, but instead that you're going to buy bonds or do something safe instead, you bet all of the money on a single blackjack game. That's risky. But the cases seem to say that if you win the blackjack game, then the risk to your customers, while dishonest, stupid, non-consensual, it didn't end with a cognizable or tangible harm. But what if, and I'm just spitballing here, what if you bet on the blackjack game and you lose? Because then the customer money is gone. That's a tangible harm. And I think there are like 30 billion reasons to think that SBF and company lost the card game. So what are we saying? Sure, it's wire fraud to lose $30 billion if done in a dishonest way, and SBF has a huge but here, it's not wire fraud to place the bet, only to lose the bet. And he says the government indictment says that he placed the bet, not that he lost the bet, but he did lose the bet. I mean, he lost the bet. And an interesting note here from these arguments is that the motion to dismiss claims that the indictments don't accurately allege a scheme to cause economic loss to FTX customers because it doesn't allege that he was never going to pay back the loans. What do you guys think? I mean, was he going to pay it back? In their third brief, SBF's lawyers moved to dismiss counts 3 and 4 of his indictment. Those 2 counts are conspiracy to commit wire fraud on customers of FTX in connection with the purchase and sale of derivatives and the corresponding fraud charge. The SDNY is claiming SBF committed these offenses based on 17 CFR section 180.1, which prohibits the employment or attempted employment, that's right, you get docked just for trying, of manipulative or deceptive devices. SBF's lawyers' entire argument for dismissing these 2 counts hinge on these words in the code: in connection with any swap or contract of sale of any commodity in interstate commerce. Now, according to their brief, they believe the government hasn't properly alleged that SBF committed fraud in connection with a commodities transaction. Now, commodities are defined in the code as, actually, it's a really, really long list, and I'm not going to read it out loud. But you can pause and go read it and see that nowhere does it mention money. SBF's lawyers are arguing that because the fraud, the alleged fraud didn't occur in connection with a commodities transaction, it doesn't qualify for a criminal charge. They believe the, let's say, borrowing, for argument's sake, of FTX customer funds was a totally separate instance from any commodities transactions. This is not crazy. It's actually not. And here's why. The rules that the courts and the SEC have put out, including the Howey test, would suggest that the FTX token, FTT, is not a commodity, but instead a security. A second argument that they make for dismissing these charges is that the alleged conduct occurred in a foreign country, and the law applied for these charges doesn't apply to extraterritorial conduct or extraterrestrial. FTX, as you know, was an international business that was organized in Antigua and headquartered in the Bahamas. The SDNY is claiming that Friedman's statements during the hearing before the U.S. Senate and a U.S. bank account in his name are enough to qualify for the charge. But SBF's lawyers disagree. Nice try. Some of the acts were committed, if they were committed, and if they were illegal, inside the U.S. I don't like this argument. But attacking FTT as being a security and not a commodity, I think they may be onto something. But this is such an odd spot, because to have a renegade crypto guru like SBF taking the sometimes implicit and sometimes explicit position that FTT is not a commodity, but instead a security, well, that's like closing Pandora's box. It's not the direction in principle that you would think Sam wanted to go. But also, he would like to spend less time in federal prison. If possible. And so prison makes strange bedfellows, and the threat of prison can make strange bedfellows, I guess. I don't know.
After all, negotiations make strange bedfellows.
The next charges on the potential chopping block are charges 7 and 8, conspiracy to commit wire fraud on lenders to Alameda Research and wire fraud on lenders to Alameda Research. Now, are you sensing a theme here? In the indictment, the Southern District of New York is claiming that SBF used interstate wires to provide false and misleading information to Alameda lenders about the financial condition of the company. SBF's team makes several arguments that these charges, starting with the argument that no property interest is alleged that would make this wire fraud offense valid. Since the indictment only mentioned the scheme to defraud post-lending and not pre-lending, the alleged fraud scheme wasn't meant to steal money, but simply misrepresent Alameda's financial position. Now, according to them, lying about the health of your business doesn't constitute wire fraud unless you successfully gain money or property from the victims. And since that isn't the alleged purpose of the alleged scheme, there's no valid wire fraud, according to them. Yet again, this is not a loony argument. It's not crazy. To understand this better, at least according to SBF's lawyers, it might help to think of this analogy. Alan goes up to Bob on the sidewalk, and Alan says, "Bob, I want to borrow $5,000, and I'm good for it. I am wealthy. I'm just short on cash today. In fact, look at this car I just rolled up in, right here." And he points to a Bentley, sitting just a few feet away. Bob knows that only rich people have Bentleys. So he loans Alan the money, confident that Alan will repay him. Now, the law is clear, and I think SBF's lawyers would agree that if the Bentley does not belong to Alan, but actually he pushes a RAV4, to quote Jay-Z, then that's fraudulent. Alan tricked Bob. He lied in order to get money, and it worked. But what if Alan asked for the loan? He never mentions what car he drives, and Bob lends Alan the $5,000. And then, after Alan has the money, he says to Bob, "Oh, hey man, I totally forgot to mention this, but I drive this Bentley right here." Now, Bob might think it's weird that he drives a Bentley, but he needs to borrow $5,000 from a stranger, or he might want to go for a ride in the Bentley with him. Or he might even feel better about his chances of ultimately getting repaid. But isn't it a harmless lie? They did the deal. So Bob shouldn't complain once he finds out about the RAV4. And that, in the simplest terms, complete with an out-of-date hip-hop reference, is what SBF's lawyers are saying happened in this situation, and why the lender counts should be dismissed. Again, if true, it's not crazy. It has some sense to it. They also don't agree that the indictment has a substantial claim that Alameda lenders suffered any real, actual property loss or damage from the alleged scheme, as the indictment failed to include any information about the loans that were involved in the alleged scheme that would suffice as property under the wire fraud statute. Now, I very much doubt that this matters. I view this as kind of a throwaway argument under the umbrella of the better argument that it's kind of a no harm, no foul situation. When he filed this motion, I thought, wow, this is going to be a joke. And honestly, some of the arguments are imaginative, but some of them are real arguments. And because the way our system of criminal law enforcement works, it doesn't usually pay for a prosecutor to be aggressive, to overcharge or over-indict someone. But it does happen. And when it happens, the defendant can sometimes go free, even though they lost their case at trial, because an appellate court believes that the law was not strictly followed. And of course, the way to preserve those rights for an appeal are to raise them in your briefing. If you lose at trial, you appeal. But if you don't raise the arguments, you waive them. No bueno. No, it's not just that though. Because sometimes a trial court will grant part or all of one or some of your requests. And then you're just staring down the barrel of a shorter jail sentence. So it matters. I would expect the court to rule on these motions sometime in the next 60 days or so. Although the judge is going to have to do a lot of summer reading. In addition to the benefits that these types of arguments offer criminal defendants, let me propose a couple of other potential benefits. First of all, if your arguments succeed in smoking out any uncertainty or doubt in the prosecutor's office about the legal strategy that they've employed, then you might get a more meaningful plea bargain discount, because they might not want to take the risk of an adverse court ruling and making bad law for the prosecutors. Secondly, and this is an even better deal, if you do win some of your arguments when you go to make your plea arrangement, the total risk that you are facing in terms of jail time is lower. And so it's easier, at least in theory, to get an agreed shorter sentence recommendation. That's high value. So as you can tell, SBF and his attorneys are fighting tooth and nail to whittle down the chances that SBF spends the rest of his life in jail. Now, whether they'll succeed or not is for the judge to say, but nothing has stopped me from speculating, and nothing should stop you from speculating. So drop your comments, your pro se opinion, down below in my comment section. What are your thoughts on the arguments that SBF's lawyers are making? Have they introduced any doubts in your mind? Let me know what you think after you lawyer up and subscribe for your own SBF briefs from me, America's Attorney, and I will see you very soon. Bye.